Do you swear or affirm that the testimony you provide will be the truth, the whole truth, and nothing but the truth?
Yes.
It's the bizarre case that has rocked the small, preppy town of Princeton, New Jersey. A former top student and soccer star accused of a gruesome killing of his own brother inside their luxury apartment. The details of this case are gruesome, involving a golf club, knife, an eyeball, and a cat. We're on the case presented by Law&Crime. I'm Chris Stewart. We have new details in the case of Matthew Hertgen. People who knew him in high school and college knew him as someone who so many people strive to be, a top student in the classroom playing soccer for one of the most elite colleges in the country. But now he is accused of an unthinkable crime. This is Matthew Hertgen in court last week. We'll show you what played out in the courtroom in just a moment. But first, I want to tell you the new details that we're learning from the probable cause affidavit that police released. It paints a clearer picture of what Hertgen is accused of doing on February 22nd. According to the document, police received a 911 call from Hertgen who said there was a fire and a dead body in his apartment. He told dispatchers the dead body was his brother Joe. Now, Joe was a former star soccer player at the University of Michigan. Here's a tribute that the Wolverines soccer team put on X to their fallen alum. The 27-year-old was also at the start of a truly promising career. He was an analyst at a financial services company. Police say they found Joe on the ground in the dining room of the apartment, and he appeared to have been struck in the back of the head with a golf club, which lay on the floor near him. Police also say that the victim had a large cut in his chest. Now, this next detail, I will warn you, it is hard to hear, but police say that Joe's eye was missing, and they note that there was a large cup full of blood along with a plate and utensils smeared with blood on the dining room table. There was also the body of a cat that appeared to have been beaten and burned. According to this court document, police say Matthew had abrasions and scratches on his hands, and when officers asked him what happened, he said, quote, that he went into a fit of madness maybe like 40 minutes ago. Matthew was arrested and made his first court appearance in a detention hearing a week later, and here's a recording of what happened. Then this past week, on March 7th, Hertgen appeared once again in court, this time for a pretrial hearing.
We are back on the record. Again, good morning, everyone. We are here in the Mercer County Criminal Division. I'm Judge Amber Gibbs, and it's February 27, 2025. The first case that's listed for our pretrial detention motions is State v. Matthew Hertgen under warrant number 2025-27-1110 and prosecutor file number 25544. Appearances for the record.
Morning, Your Honor. Assistant Prosecutor Tim McCann on behalf of the state.
Good morning, Your Honor. Jason Maddie appearing on behalf of Matthew Hertgen, who is present by video for today's detention hearing.
All right. Good morning, everyone. State, I'll hear from you first.
Thank you, Judge. At this time, I'm requesting a 3-day statutory adjournment. I am still in the process of obtaining and providing discovery to Mr. Maddie.
All right. Counsel?
Your Honor, there is no basis to object. This is a statutory adjournment that is allowed under the legislature. We had previous communications prior to court today, and that we have all agreed that this case come back on March 6th at 11 a.m. before Judge Wilson. So I guess that would be 3 days for the defense and then statutory days attributable to myself.
All right. And so I have the 3 days statutory, and then that will adjourn to next week. And then the 2 days that's requested by defense. And that will bring us to Thursday, March 6th at 11 a.m. before Judge Wilson. Now that will be in-person, counsel.
That is what has been agreed upon between all parties.
That's my understanding as well, Your Honor.
All right. Then this matter will be reset for March 6th at 11 a.m. before Judge Wilson. All parties to be in person.
One other thing, Mr. McCann, I do have the affidavit of probable cause and the complaint. I would just ask, I know we've worked together for a long time. Whenever you do come into possession of additional discovery, if you could forward that to me, because I plan on meeting my client on Tuesday, March 4th at the jail. So hopefully I would have those materials to review them with my client in preparation for Thursday, but we can talk.
Of course, as soon as I get the reporting and the rest of the story, I'll turn over everything. Thanks.
Thank you so much. And Matt, I will see you on Tuesday, March 4th. You can leave the booth.
I want to take a moment to thank Upside for sponsoring this episode of On the Case. Upside's a free app that gives you cash back for buying daily essentials like gas or groceries. I downloaded Upside, went to a gas station about 4 minutes from my house, filled up my tank. I got roughly $7 cash back. Upside, it works at gas stations, but also convenience stores, restaurants, places you typically go, but you end up getting cash back. What you do, download the free app, choose one of the options, pay like you normally would with your credit card or your debit card, and then you get cash back. It first goes to your Upside app, then you transfer it to your bank account. It is that simple. So scan the QR code on your screen to download Upside, or we have a link in the description of this video. And on top of that, I want you to use promo code OTC. That will give you an extra 25 cents back per gallon when you fill up your first tank of gas using Upside. Now, when you watch that video, obviously there was a lot of procedural steps that were taking place in New Jersey, but there is something to take away from that, and that is Hertgen sitting there with his defense attorney and answering questions. Briefly, one-word answers, but recognizing what appears to be the situation that he's in. Now, this is clearly a gruesome crime that would be shocking for anyone to be accused of, but what has made this story get so much attention is the life that Matthew Hertgen grew up with. Social media shows that he looked very different in his college years at Wesleyan University in Connecticut. Tuition at Wesleyan before financial aid is nearly $70,000 a year. But Matthew's Facebook also tells a story that may line up with what the oldest brother told investigators according to those court documents. David Hertgen told police that Matthew suffered from severe mental illness over the past 5 years and struggled with having visions. David had spent time with Matthew the night of Joe's murder and told police that Matthew seemed, quote, distressed, despondent, and experiencing terrifying visions. When you dive into what Matthew posted on social media, you can also see that he started posting these drawings, as well as some long poems that describe graphic scenes that some have said laid out his plans for what he is now accused of doing. On September 6, 2024, he writes, quote, he still has a pulse. Blood still flows through his veins, but something is wrapping around him, squeezing him, choking him, suffocating him, tightly wound around his head, fastened deep in his throat. Blood oozes out of his eyes. His ears are sparking. His face vibrates. He convulses, and he doesn't stop. He's lost, he's asleep, he's dead. On February 21st, around 1 o'clock in the afternoon, Matthew posted this picture on Facebook. It was before 11:30 p.m. the next day. Police say he called 911 about his brother's dead body. Laying next to him in that picture also appears to be a cat toy. And remember, police also said that he killed the family's cat by setting it on fire. According to police, the older brother, David, had spent time with his brother Matthew the night that Joe was killed, and he left the apartment unit where Joe was found dead around 10 p.m. Police say that David texted his brother Joe that Matthew was struggling with his visions, and if he needed to help, to let him know, and Joe said, quote, will do. David also texted Matthew to go on a hike the next day and to, quote, hang in there. He didn't hear back. It was roughly 45 minutes after David texted Joe that Matthew called 911, saying that Joe was dead in the apartment, and police responded to uncover the horrific crime that Matthew is now accused of committing. Joining us now from New Jersey to talk about this story once again is Michael Korobanix, certified criminal defense attorney. Michael, always great to have you on Law and Crime. So it's come to light that Matthew Hertgen had been dealing with some mental health issues over the past 5 years. How could that factor into how this case progresses going forward?
It could factor into it very strongly, because if he actually had mental health issues that they find would not enable him to have a intention to do what he did, and it was just a mental breakdown, that could be a very strong defense and could persuade perhaps the court that he would need some mental health rehabilitation if in fact he is guilty of this, and that this was a factor that didn't cause him to have the intent to commit this murder.
How does that now play out in the courtroom, where if you're the criminal defense attorney and you're able to say that he's had these mental health issues? I don't know if he was diagnosed with a particular condition, but mental health has been an ongoing issue. What is the approach to actually then get that potential insanity defense in front of a jury?
Well, what you would need to do is you need to get a independent mental health expert who would review all the documents previous, if there are no previous documents, just to do a mental evaluation of him at this time when this occurred. And then there would have to be discussions with the government and to see if there was some sort of agreement to say, that they have nothing that could contradict what the defense has proven, or if they do, there would have to be a hearing to see where that goes.
Because I think for many of us on the outside of the criminal defense world, clearly you'd be in a different mindset to take a life in any kind. What's the bar that would have to be met for it to actually, in the eyes of the court, be insanity?
Well, what it would have to be is to show that the main thing with a murder is the element of intent. Did they intend to commit this murder? And if there's some mental health issues that are presented that the person didn't realize what the reality was that was going on, then that would be the insanity defense. And it would be saying that he didn't have the intent to commit the murder, but there was things in his mind that distracted him and didn't allow him to know even what was going on.
This is, and as we've read more about it and more details have come to light, I mean, to say it was a gruesome murder is putting it lightly. It was hard to read. It's hard to talk about with, some of the details related to the victim's eye. I mean, I won't go into it anymore. How gruesome this killing appears to have been factor into whether or not that could lead to him being in not the right mindset in the eyes of the court?
Well, it could factor into it very strongly. And what I think also is very strong in the insanity type of defense is you very rarely, and I hope I have this correct, my understanding is after this incident occurred, he is the person who called the police.
Right.
So that's very unusual to hear someone who commits a murder, who intends to commit the murder and to put a life away and move ahead, wouldn't leave the scene, wouldn't be at a place where he couldn't have any proof that he was there. So that's a very interesting part of this case. And there would have to be a lot of review of a lot of the documents and the proof that the law enforcement says they have to see exactly, did he admit to this afterward? Did he just say, because there were some parts that said that he said he wasn't going to talk about it when he made the call. But then there are some articles that say there were statements given afterward. So there's going to be a lot of issues here as to the Miranda hearings, meaning did he understand his right to remain silent if he was a suspect in this murder?
Because that was kind of led into my next question. Was he did say in the police report when they asked what had happened, and it was related to some wounds he had on his hands, and apparently he told officers that he just, I don't know if it was the direct quote, but like, I lost it about 40 minutes ago, which from public opinion, you look at that and you say that this was someone who admits that he just killed his brother. As a criminal defense attorney, you see a statement like that on a police report. How do you approach it if you were going to be defending this person?
Well, you'd have to, the first thing is that the burden is on the state and the government to prove beyond a reasonable doubt. The defendant has a presumption of innocence. So what you would need to do is, in the defense, is see, can the government prove, based upon the relative facts surrounding this incident, that this statement, in fact, connects to an intent to commit a murder? Quite frankly, speaking here and just exchanging our thoughts, the government has some very strong evidence in this case. So, it's like, I will always tell my clients I'm a criminal defense attorney, not a magician. So you have to really evaluate what the facts are in the case and what is the best way to see how you can put your client's life to go forward without risking him in this kind of incident to be incarcerated for the rest of his life.
Yeah, like when you get in those positions where your client maybe is expecting a little bit of magic, and you're heading into a case like that where the cards are stacked against you, like they appear to be at this point for Matthew Hertgen. What's the mindset you're in as a criminal defense attorney?
Well, the mindset you'd be in is to make sure you evaluate all the proofs they have. You really have a very big responsibility to go over it all with your client and explain it to the client as best you can, and rely on the client of doing what the client wants to do to be truthful, to either put this behind him or take the risk. There also could be an incident, quite frankly, in a case like this where the government offers you a plea agreement where you really take no risk because the plea agreement's so high that you would go to trial and see what is out there.
How likely would a plea be in this case, where ultimately, if you're the prosecution and you have all this evidence of what took place, how likely do you think it would be that the state of New Jersey would offer some sort of plea to Matthew Hertgen if we see this continuing going forward, and then obviously all the evidence proves to be true from what police have said?
Well, I think a lot of that's going to turn on the mental health evaluation and where it goes with this defendant as to where the government exactly will be going with it. And also, it's an unusual situation because, well, not unusual, I mean, it occurs, but it's very rare where you see this, where a family member is killing another family member, because usually whenever there is a resolution to a case, of course, the government is going to consult with the victim, and if there is a victim who has passed away, the victim's family, as to what's acceptable to them and where they want to go. Although that's not the ultimate thing that makes the decision, it does play a big role with the government as to how they're going to resolve the case.
Have you ever seen a case like this? I know you've had a long career in criminal defense, and some stories are more gruesome than others, but to see the family aspect of this, certainly the background they had as a wealthy family, and then for it to be just such a gruesome death, I guess, how often have you seen a story like this?
I really haven't seen a story like this where, like, and you pointed it out really very well, is that it's so intertwined, and the family is, it appears from what it is, the family was close. I mean, here the brothers at that age, 31 and 26, were still in the same home together when this occurred. So it's not like, it doesn't appear from the facts we have, and I don't have all the facts, that this was something where there was some sort of ongoing fight between them. They had to be separated. They couldn't be together. So this is unusual. And what's really unusual is I can't recall ever having a situation where a client, after allegedly committing this type of crime, calls the police and remains where they are.
Yeah, it'll be an interesting 911 call if that ever gets released. I mean, is that something that, as a criminal defense attorney, you would use as evidence, actually getting the tape recording and then trying to argue that could be played in court for the jury?
Yeah, absolutely. Absolutely. But, it's very difficult until you hear it exactly, because, I mean, we have an idea of what the words were when he called, but you also want to see how the jurors will potentially interpret the mode and the way that the words were spoken. Were they yelled? Were they screamed? Were they spoke calmly? How were they spoken? And that's something that also goes into interpretation of how a jury is going to interpret that statement that is on tape.
As someone who's been in New Jersey courtrooms, I mean, how effective is the insanity defense? I'm sure if you go to some states, there are jurors that may not be as, I don't know if sympathetic is the word to that type of argument, or understanding to an insanity defense and a mental health being a reason for a defense. Typically, how does that go in New Jersey courtrooms?
Well, it goes pretty much like in any other courtroom. A lot of it depends really on the expert and how the expert puts it forward. But really, once again, it goes into your jury selection to make sure that you have jurors who are living up to the oath they take, which says they will be fair and be non-prejudicial, or use their own sort of instincts as opposed to evaluating the evidence that's before them and see if that evidence comes up to a point to prove beyond a reasonable doubt that the defendant is guilty.
And that actually brings up a question that I forgot to ask, would be who the expert is that will do the mental health evaluation. Is that someone appointed by the state, or is that someone that the defense can bring forward to use as an expert in the trial?
Well, the defense would look for their own expert because the state will be getting their own expert.
Right. There's no
now,
like third party type person who would kind of both parties would agree on.
Yes, usually, especially if it's I'm pretty sure, but it's been a while since I've dealt with the public defender's office, but I'm pretty sure the public defender's office would have some sort of approval for the expert that is going to be used in this case.
Yeah, and it'll be interesting to see. I know that he has several court hearings. At least the next one is expected later in March. And knowing the time, how long it takes to typically do these mental health evaluations, and then looking at whether Miranda rights were given at the right time. What timeline would you think that this type of case would take to actually get to trial if it gets to that point, recognizing that he was arrested, I believe it was February 22nd?
Well, that's a question that I honestly can't answer because a lot of things have changed so much since the pandemic. And I know that seems like it was so long ago, but there are cases that were backed up because of that. So there is a long line of where this is going. And also one of the things that will be very important in evaluating when this needs to go to trial is how much time the defense has to prepare this case, since you're talking about experts and things of that nature. So this could take maybe from a year to 2 years, something like that. Wow.
Yeah, it's always incredible to see the timeline going forward. And this story, every time it comes up, I mean, it's hard to read knowing the details, but it's one that's getting a lot of attention. Michael Korobanix, a certified criminal defense attorney from the state of New Jersey. Thanks for taking the time to be with us. We appreciate it.
Thank you. It was a pleasure being on. Thank you.
Matthew Hertgen is expected back in court in New Jersey on March 24th. If convicted, he could face at least 30 years to life in prison. For On the Case, presented by Law&Crime, I'm Chris Stewart. We'll see you next time.